This chapter will be an overview of contract law. Contract law reflects our social values, interests, and expectations with respect to arrangements, commitments, promises between parties. What kinds of promises does our society believe should be legally binding? Contract law also distinguishes between promises that create only moral obligations and those that are legally binding. For example, a promise to marry someone or a promise to take someone out to lunch at some date in the future creates only a moral obligation. Compare this to a promise that is legally binding, such as a promise to pay for the lunch that one orders at a restaurant, or a promise to pay for the article of clothing that one wants to purchase from a retail establishment. A contract is formed by two or more parties who agree to perform or to refrain from performing some act now or in the future. It is an agreement that can be enforced in court. Therefore, it's not just simply an agreement, but it is an agreement that can be enforced in court. Now, again, when we speak about parties throughout this chapter, the party can be an individual, it can be a business, or it can be a corporation. Under contract law, the courts look to intent in determining whether a contract has been formed. Intent is of prime importance. Intent is determined under the objective theory of contracts. A party's intention is judged by outward objective facts as interpreted by a reasonable person, rather than a party's internal, what were they thinking, subjective intentions. What did the parties say? How did the parties act? What are the circumstances surrounding the transaction and the arrangement? For example, let's suppose that you're outside, it is early in the morning, and you see your neighbor come out of his house next door, very frustrated, attempts to turn the key to start up his car. It's a brand new car. He purchased it for $30,000. He's late for work, very frustrated. The car doesn't start. And in frustration, he yells at you, "I'm ready to dump this car. I will sell it to you for $5,000. Do you want it?" And you say, "I accept your offer." A court would look at all of the facts to determine whether or not your neighbor intended to sell his car, or whether or not those remarks were really just born out of frustration. To have a valid contract, 4 elements must be met: agreement, consideration, contractual capacity, and legality. The first element is agreement. Agreement includes both an offer and an acceptance. Secondly, consideration. Consideration is something of value that is either received or promised that convinces a person to make a deal, to enter into a contract. The third element is contractual capacity. Both parties entering into the contract must have the contractual capacity to do so. For example, there are rules around the contractual capacity of a minor, or the contractual capacity of an intoxicated person, as an example. We'll discuss that later in the semester. Legality is the fourth element. The contract's purpose must be to accomplish some goal that is legal and not against public policy. In other words, the contract must not be for an illegal purpose. Two drug dealers, as an example, enter into an arrangement and enter into a contract, even if it is written, to sell drugs or to engage in some type of drug trafficking activity. That contract, that written piece of paper, does not have a legal purpose. Therefore, it would not satisfy this fourth element, even if one of the parties attempted to enforce it in court. All contracts involve at least two parties. One is an offeror, the party that makes the offer, the promise to do something, or the promise not to do something. For example, I offer to sell my car, or I promise to refrain from engaging in some type of activity. And there's an offeree. The offeree is the party to whom the offer is made. And a contract cannot involve one party alone. Contracts may be classified as either bilateral or unilateral. A bilateral contract is formed when a promise is given in exchange for a return promise. A contract comes into existence at the moment that the promises are exchanged. For example, I promise to sell you my phone for $200. The offeror states, I accept your offer and promise to buy your phone for $200 next Friday when I get paid. At the moment that the promises are exchanged, a bilateral contract may have been formed. In a unilateral contract, the offer can be accepted only by an offeree's performance or act, and not by some type of return promise. For example, as an offer, I will pay you $1,000 to drive my car from New York City to Los Angeles. Well, the performance is actually driving the car to Los Angeles. That is when the contract is formed, when the performance or the act occurs. Another offer, I will pay you $1,000 to provide photographic services at my graduation. The offeree does not accept by merely stating, I agree, I will do it. Rather, the acceptance occurs when the actual photographic services are performed. Once performance has been substantially undertaken, the offeror cannot revoke the offer. As an example, in the first hypothetical, I provide the keys to my car to an individual in New York City who will drive the car to Los Angeles. The individual begins driving. Once they reach Iowa, midway through the country, I call the individual and tell them I revoke my offer. Performance has substantially been undertaken. At that point, I cannot revoke the offer. However, same hypothetical, I give the keys to the individual in New York City, and before commencing driving the car, I call the individual and say, I revoke the offer. I have a different way. I will drive the car myself instead. At that point, performance has not been undertaken, substantially undertaken. I am entitled to revoke the offer. Exhibit 10-2 in the text provides an illustration about contract enforceability. Let's focus first on the upper left-hand purple box, a valid contract. Once the four necessary elements have been satisfied, a valid contract exists. Those four necessary elements being an agreement, consideration, legal capacity of the parties, and a legal purpose. Once a valid contract exists, the question then is whether or not it is enforceable, voidable, or unenforceable. Let's start with enforceable. A valid contract will be enforced by the courts if there are no legal defenses against it. A legal defense may be duress or the statute of limitations. We will study valid defenses later in the semester. Is the contract voidable? Voidability means a party to the contract has the option of either avoiding it or enforcing the contractual obligation. And finally, is the contract unenforceable? Meaning a valid contract does exist, but it cannot be enforced because of a legal defense that exists and that is recognized under the law. Now, let's also look at what is a void contract. A void contract essentially means that no contract exists. There is no contract because one of the four elements has not been satisfied. And all of the four elements must be satisfied. If one of them is not satisfied, there is no contract. A voidable contract, as we mentioned, is a contract that may be legally avoided at the option of one or both of the parties. For example, a minor may, at the minor's option, avoid a contract. Was there duress or undue influence? An unenforceable contract, for example, means that while a contract exists, it cannot be enforced due to a legal defense that is recognized. For example, some contracts must be in writing to be enforceable. A void contract is a contract that has no legal force or binding effect. In other words, there is no contract at all. The four elements that are required to be satisfied have not been met. At least one of the contract elements has not been met. For example, one of the parties may be mentally incompetent, or the contract purpose may be illegal. Those are two separate elements, but if even one of those elements is not met, then there is no contract at all, or it is a void contract. It is common for parties to agree that a contract has been formed, and in fact, a valid contract has been formed. All four elements have been satisfied, but the parties may disagree on the contract's meaning, or the meaning of certain key terms or provisions. A contract dispute may arise because the rights or the obligations under the contract are not expressed clearly. The courts will take various approaches to interpreting the contract, and we will review those later in the semester. However, no party can avoid a contractual obligation by claiming that they did not read the contract. The plain meaning rule is an approach used by the courts to interpret contracts. When a contract's language is clear and unequivocal, the court will enforce it according to its obvious terms. The meaning of the terms is determined solely from the face of the instrument, solely from the contract itself. The contract words and their plain ordinary meanings determine the party's intent when they entered the contract. Under the plain meaning rule, a court will consider a contract or a contract term to be ambiguous in the following situations. The intent of the parties cannot be determined, when the contract or a term lacks a provision on a disputed issue, a term is susceptible to more than one interpretation, or there is some sort of uncertainty about a provision. Now again, under the plain meaning rule, if the contract or its terms are unambiguous, the court will interpret the intent of the parties based on the face of the instrument, based on the terms contained in the contract itself. However, this slide discusses when and under what circumstances will a court consider a contract to be ambiguous. Now, when a contract is considered to be ambiguous, what happens? When a contract or a contract term is considered to be ambiguous, then extrinsic evidence may be considered. Extrinsic evidence is evidence that is not contained in the document itself, but it may be considered in interpreting ambiguous contract terms. For example, testimony of the parties, or additional communications or agreements. For example, emails, or other notes that have been taken, or other relevant information that can be used to determine the party's intent. But as mentioned earlier, if the contract is clear and unambiguous, then extrinsic evidence or evidence outside of the contract itself is normally not considered.